moment. Good morning, Mr. Bartenstein.
Good morning, Your Honor. May it please the Court, my name is John Bartenstein, and with Mr. Lucido, I represent the two citizen groups that have brought this appeal. The case involves a wetlands permit issued for the Hoosac Wind Project. After a 10-day trial, an administrative law judge issued a recommended final decision in favor of the citizen groups. The ALJ found that the proposed roadway for the project would require the construction of a number of culvert crossings that were subject to but did not comply with the performance standards for inland bank. The acting commissioner of the DEP rejected that recommendation and ordered the issuance of a wetlands permit. The citizen groups respectfully submit that the acting commissioner's final decision was erroneous and must be overturned on 4 grounds. First, the acting commissioner relied on an erroneous interpretation of the wetlands regulations. Second, her decision was not supported by substantial evidence. Third, she failed to comply with the requirements of the appeals court's Vinal decision. And fourth, and finally, the traditional culvert crossings proposed at 2 of the streams alone would trigger a wildlife habitat evaluation, which was not done.
Mr. Bartenstein, could I ask you a factual question? There's a dispute as to where the upper boundary of the bank is versus the lower boundary, and am I correct that that's a matter of inches?
No, Your Honor, we would not agree that it's a matter of inches.
Is it a foot, 2 yards? What are we talking about here?
It might depend on the particular stretch of stream and stream bank one is dealing with. They have different contours, different characteristics. Some are relatively steep, where the water's coming down a steep slope. Some are more flat. But ultimately, it wasn't necessary for us to resolve that dispute because the acting commissioner assumed, for purposes of her decision, that the highest level, the first observable break in slope, which you can see in photographs,
Sure.
would be the assumed upper boundary of the slope.
If we were to agree with your position, what would that do to a buffer zone? Are we creating a buffer zone of a buffer zone? In other words, as I understand the problem is that there seems to be no dispute that it doesn't actually physically touch the bank. Am I correct?
Once the open bottom culvert
I'm talking about the open bottom culvert.
Yes, once that culvert's construction is finished,
right,
it's designed to span across the stream and the banks from footings that are on either side of the bank. It's sort of an arch that's dropped on top. That does not mean, however, that the process of constructing the culvert would not require contact with trees that have to be cut on the bank, and in order to dig the trenches, which are right next to the banks, you have to dig a 2, 3, 4 foot trench, and there may be rocks and boulders and bedrock in there that have to be removed, and our position is that that is part of and supports the bank. But once the culvert is in place, yes, it's designed to span not very far over, only a matter of a foot or 2 over the surface of the bank. And remember, these are very, very long culverts. The road width is up to 60 feet wide, and culverts are actually, they refer to it as the length of the culvert from the right side to the left side. And that spans anywhere up to 60 feet long, which is effectively creating a long, dark tunnel immediately over the surface of the bank.
But there's no question that these can be built. I mean, are you saying, well, they just can't be built?
No. We're not saying at all that they cannot be built. In fact, our experts essentially agreed, and we've been very forthright and upfront about this throughout the case, that the open bottom culverts may indeed be a preferred design alternative for this and other projects.
Yeah, I understood that.
What we are also saying, however, is that simply because we're using a new technology does not mean that the bank performance standards disappear.
So what is it that what else needs to be done?
Well, first of all, the regulations are very clear that if a project is going to alter more than 50 linear feet of bank.
Alter, and what you're saying here now is you might have to cut some trees on the bank.
Yes.
And you might disturb the bank by trenching.
Yes, and also the culverts themselves will be in place for many, many years. They are long, dark tunnels. They will completely, the evidence is really not refutable in the record, that they will shade out and destroy any vegetation that lies underneath. That vegetation...
Okay, but it's a given that that's going to happen. It's just a matter of what kind of extra standard you think should be applied to the construction of these.
But the issue is whether the culverts themselves are in the bank resource area or somewhere else. And
the consequence of them being, even though they're not physically lying on the bank or touching the bank, you're saying since they're over the bank,
they're in the bank
how far up
resource
does the
area.
bank area
Yes,
go?
and the appellees have taken the position that applying a very, very meticulous definition of one tiny piece of the regulations, that the banks do not include the airspace above. That's a complete anomaly, because if the bank resource area is limited to the surface of the bank, the buffer zone is plainly and unambiguously defined as the area extending 100 feet horizontally from the outer boundary of the bank. Clearly, the airspace over the bank and the stream cannot be buffer zone. It's not.
Can I ask you this question, just back to what you were talking with Justice Cordy? If you say they can be built and this shadow of the culvert is going to affect the and kill the vegetation underneath it, and so what would you say should happen?
Okay, first of all, the regulations very clearly require the conduct of a wildlife habitat evaluation when there will be an alter of more than 50 linear feet of bank. The definition of alter plainly and unambiguously includes the destruction of any vegetation. It's a very broad term. All the parties in this case have agreed throughout that that term is very broad. Once you go over that threshold, there's a requirement to perform this evaluation. They're specified in the regulations the credentials of the person to perform it. And then depending on the outcome of that evaluation, there may be ways that you can, well, first of all, it's conceivable that you could find that there would be no impact on wildlife habitat. That's unlikely because even the briefs that have been presented to the court in this case have acknowledged that wildlife habitat is significant here. But in any event, there are provisions in 310 CMR 10.60 for mitigation of that wildlife habitat loss by restoration or replication. In fact,
if you had a higher culvert, I mean, I suppose what both Justice Cordy and Justice Botsford are pushing at is, assuming that you went through the wildlife habitation evaluation, what's the solution? Is the solution no load, or is the solution a higher culvert letting in more light? I mean, what's the...
Well, one solution, Your Honor, and the solution originally proposed at the outset of this project when the pipe culverts were going to be used, was to replicate stream bank, to create a copy, in effect, of the bank that would reproduce the habitat, but at the same elevation, the same general level. That was rejected initially by the DEP because the replication proposed was not at the same elevation, but was much further down the hill.
I have a question. The New England Wind states that you ignore that your own witnesses testified in favor of the open bottom culverts. How do you respond to that?
Well, once again, Justice Cowan, we've been very clear that our witnesses never said that open bottom culverts are the wrong choice for this project. I think it's been generally agreed that all in all they are better than the traditional closed culvert. It's a new technology. Our witnesses testified that the concept of an open bottom culvert is when it's constructed, it won't touch the bank. We've not denied that, ever. That's true. Our witnesses never said that the culverts would not be in the bank resource area. They never said that they would have no impact on the bank. They clearly will. And indeed, let me address this issue about the airspace. The airspace is a critical issue. Essentially, we have resource areas that are defined in the regulations. We have buffer zone that's defined as 100 feet horizontally outside. And then the question is, well, what do the regulations have to say about airspace? And when this argument was made, we realized that the regulations are very clear that there's one form of activity that's absolutely unquestionably in the airspace above a resource area or above a buffer zone that's treated as an activity subject to regulation, even though it never touches the surface, and that's vista pruning. The vista pruning concept essentially is that if somebody has a house and they want a better view, they can clear out tree canopy, but only up to 10% of that tree canopy. They have to leave 90% of the tree canopy intact. The regulation exempts as a minor activity. Minor activity. It's not an activity at all. It's a minor activity. Vista pruning that leaves 90% of the canopy intact, but only if it's in a buffer zone or riverfront area outside of a resource area. The regulations are absolutely clear that that exemption does not extend to resource areas, including bank resource areas, and it would not be permissible to, for example, if the project proponent here were to drive a large bucket truck up to the edge of the buffer zone, remain in the buffer zone, then send a telescoping bucket up and clear out all the tree canopy above these streams. Now we have forested streams that are shaded. It protects the wildlife from the shading. And now we have bright sunshine pouring down onto those banks. The banks dry up, and everything changes.
Is that a separate regulation, or is that simply covered
It's an
by
exemption.
this set of regulations?
It's an exemption, Your Honor, that was created. By the way, there's a very short 2-page guidance sheet that we located that had been issued by the DEP explaining to conservation commissions exactly how to deal with this vista pruning. And it's in the back of our reply brief.
How is it measured? How is that the 10% versus 90% measured? 10% of what? Of what greater area?
Yeah, well, we actually had some testimony in this case about the amount of canopy. There was an issue as to whether or not the open bottom culverts would have a significant impact on the banks because there was already tree canopy shading the banks. Our position, of course, was that whatever shading from the tree canopy didn't approach the shading from the culverts. There was testimony by some of the appellees experts.
One solid black shadow and the others filtered
Right,
shadow.
where they basically take measurements of light underneath the tree canopy, and they measure the percentage of cover, and there are instruments that can do that, light meters.
And what is the consequence of the order of conditions which bars construction on the bank?
Yeah. That is a very peculiar provision in the preceding order of conditions. In effect, it's as though someone says to a child, you can swim, but don't go in the water. The administrative magistrate effectively found that it would not be possible to build, construct, install these open bottom culverts without having an effect in the resource area and impacting the bank. And to simply write an SOC that says you can do this project but don't touch the bank is an impossibility. It can't happen. There are photographs that we attached to the back of our principal brief showing very large trees right in the pathway of the roadway. There is no way that you can build a roadway and a culvert crossing without removing that tree.
So if they were to violate that condition in construction, which you say is inevitable, what happens then?
I'm afraid it's too late. If the roadway is underway, the project is gone, and it's almost as though we asked for a preliminary injunction and we didn't get it. They proceeded to build the property, and then after the fact we came along and said, well, the road's been built and it's destroyed wildlife habitat, and but we didn't get an injunction, so we couldn't stop it. And I don't think this is a situation where there's an adequate remedy after the fact. These are important environmental resources. The wildlife habitat evaluation can easily be done and has not been done. And to allow the project to go forward and in a way that is obvious can't be done is, in my opinion, to completely disavow the responsibility of the DEP to actually take a meaningful examination and condition a project in a meaningful way.
Mr. Bartenstein, am I correct that you've really got two major thrusts which are related but separate? The one is the airspace, so that if you put anything over even if it's an open bottom culvert and so on, it's going to have an impact. And the second is, when you put whatever the footings or whatever it is that's going to hold this upturned U, that of necessity is going to destroy the bank or impact the bank itself.
Yes, Your Honor, and I would just add to that the cutting of very large trees that are in the way of the culverts, and those trees are growing right out of the bank, and they have extensive root systems that hold the bank together.
And they're going to be, those are trees that are part of the bank?
Yes.
Okay. So I'm sure you're aware of the amicus brief which has been filed by the Association of Massachusetts Wetland Scientists.
Yes.
It seemed to me that they were focused on the work in the buffer zone.
Well, this has been a characteristic of all the briefs we've received in opposition, is they simply assume the conclusion that all the work is in the buffer zone. And they argue, well, goodness, we can't apply performance standards to work in the buffer zone. But that's not the point of our argument. Our point is that this work is in the buffer zone.
No, in the resource area.
Excuse me. Thank you very much. Not a good way to end, but yes, absolutely right, in the resource area.
Thank you very much.
Thank you very much, Your Honor.
Mr. Bartenstein. Mr. Pardee.
Thank you, Your Honor. May it please the Court. I think it's important to state at the outset that there is no dispute about whether or not this project meets the statutory standard for work altering a wetland.
Could you begin with where Mr. Bartenstein left off? That is, what happens to these trees that one can see in the photographs have roots right in the bank?
Well, the determination of where a tree is located where its trunk is. For example, to take the example of vista pruning occurs where the trunk of the tree is, even if the branch overhangs another area. I must say, this is a particular issue. The vista pruning issue is one that was first raised in the reply brief, so we haven't had an opportunity to brief it. But there are guidances that the department has put out to make it clear that when you are determining, for example, what the coverage of an area is, the leaf coverage, you do not count leaves that belong to trees that are not
That may make
located.
sense. That may make sense if you're leaving the trunk standing. So you're leaving the trunk standing and you're taking out some of the leaves. What happens if you're taking the trunk out? Aren't you taking the roots out?
No, what you would be doing is cutting the tree at
No,
the
I
ground
understand,
level.
but de
You wouldn't be
facto-
taking the roots out.
No, but de facto, you're going to put some of that black clear site or something other, and that's going to kill, right?
So, I think that the proposal is just to cut the trees at ground level, but let me add.
Have you watched how fast trees grow in New England? I mean, you're going to have them sticking through the culvert in a nanosecond. Something is going to be done to, stop the growth of the trees right up through the...
I have to say that this is speculative. The assertion that the project necessarily will involve the cutting of large trees that are sitting right on the bank is an assertion that's speculative. It is true that the ALJ made a finding to that effect, but I think that for purposes of determining which standard applies, you have to look at the notice of intent as reviewed and conditioned by the agency.
What's the purpose of the vista pruning regulation? Is it an aesthetic concern or is it an environmental concern?
It's environmental. The issue is opening up an area to additional sunlight, which may affect its ability to supply important habitat. Mm-hmm. So it is an alteration, let's say. Mind you that just because vista pruning may open up a wetlands area, that does not mean that it occurs in the wetlands area. And that brings me back to my opening point, which is that there's no question that this project is subject to the jurisdiction of the Act. There is no question that it must be conditioned so that it protects the interests served by the Act. And there's no question that that, in fact, occurred. The issue here is whether a standard that was adopted by the department It is not a statutory standard. It is a department standard, a heightened standard for work that actually occurs within a resource area should be applied to this project. And as this project is defined, as it was proposed, these 10 crossings, as it was accepted by the department, as it was conditioned by the department, none of the work involved in installing these crossings will occur within the resource area. Now, to go back to the question of Justice
Let
Corning.
me just go back to, none of the work will occur, and so you're saying chopping off a tree is not work in the resource area?
If it turns out in installing one of these bridges, it turns out that it is necessary to chop a tree down that is in the path and happens to be on a bank, then it will be incumbent on the proponent to come back to the department and say, we want to chop that tree down. The department may at that point determine that that tree is not itself significant to the interests protected by the Act, and therefore the tree could be cut down without another round of notice of intent and order of conditions. But it may equally turn out that there are a great many of these trees and that maybe further review will be necessary. But for purposes of this project, there is nothing in the order of conditions that authorizes a tree on a bank to be cut in order to make way for this roadway.
But can't you, I mean, don't we know where this road is going to go?
I don't think we know. First of all, it is possible when you are constructing a project, and particularly a project of this scope, it is impossible to adjust the roadway one side or another if conditions on the ground make that desirable. And that would be something that, again, would be discussed with the department on the ground to determine whether that requires additional review.
And at that stage, does anybody have any standing to say, well, the department says this tree isn't very valuable because there are a ton of them, and somebody says, no, this is critical to the whole canopy, the shape, whatever it is. I mean, does anybody have standing at that point?
Well, I think the question of whether a further action could be brought, I think presumably it would be, you could bring such an action, but there is not, unless the department determines that further administrative review is required, there would not be a further administrative hearing. There would be presumably the opportunity to bring suit under 214(7)(a).
What do you say to the argument by the plaintiffs that if you take the acting commissioner's construction of the phrase work on a bank, that creates a huge exception to the performance standards? And if structures that span and cover over an inland bank are not considered work or activity within a bank resource area, then not only open bottom culverts, but also highway bridges or even big buildings that are built over and cover a bank would be exempt from the bank performance standards as long as they are designed not to touch the bank's surface.
Well, I say, first of all, that there's no question here. Nobody is contending that these bridges aren't subject to jurisdiction under the Act, and that is because they are installed based on work in a buffer area. So they are projects in a buffer area and therefore subject to the jurisdiction of the department. I'm actually, as I read that passage, I was trying to imagine a building that was hovering over the stream that was not founded on footings in a buffer or in the resource area. I have a hard time imagining a real-life project that would realize this horrible that the plaintiffs are imagining.
Well, to take the following,
But if it were the case that you had let's say a dirigible hovering over the stream for a long period to the point where it was actually affecting the vegetation, that would be subject to the Act, because the Act specifically says that any alteration of a resource
how
area.
is that how is what your response to Justice Cowan consistent, which I take it is your position, that the bank does not include the airspace above it?
Well, but the project is constructed in the buffer, and it will likely, in the judgment of the issuing agency, it will likely affect or alter a resource area, namely a bank. and therefore it is subject to the jurisdiction of the Act. You have to distinguish between projects that are, as defined, involve alteration of the bank, and projects that, as defined, are in a buffer but will likely alter a bank. Those, under the regulations, are subject to jurisdiction. They simply are not considered to be in the resource area. And there's really a very sensible, practical reason for the distinction. And that is, if you are talking about projects in the buffer is extends 100 feet from the resource area. Depending on where exactly a project occurs and depending upon exactly what impact it will have, the department needs a good deal of flexibility in devising conditions that are appropriate for that project.
So if I understand you correctly, you could have a project with footings in the buffer zone, buffer area, but depending on what that project is, you could have exactly the department imposing exactly the same restrictions as the resource, the bank performance area.
You very well could. And in fact, the regulations were recently amended after this case was underway, so they didn't apply to this case, to make it clear that for work in a buffer zone, the order of conditions should ensure protection of those interests that are of concern with respect to the adjacent resource area. So there's even a closer reference to the performance standards. It's just that if it's in the buffer zone, the performance standards as such need not apply.
So it's not mandatory, but it's certainly something that is very much on people's minds.
The department could very well have determined that a study of wildlife habitat was required for this project, but it did not. In fact, in the record, the department's agent on the ground explained that in his opinion, the project would not have an adverse effect on wildlife habitat. If there are no further questions, I will rest. Thank you.
Thank you, Mr. Pardee. Mr. McGregor? No, it's Mr. McGregor who's speaking. Yeah.
Good morning. May it please the Court, Gregor McGregor for New England Wind with Nathaniel Stevens, my associate. Time is valuable, so I should start by saying, in conclusion, is the Court comfortable second-guessing the expertise of DEP, the technical competence of DEP, the special knowledge of DEP, and the discretionary authority given to DEP by the legislature in the first Wetlands Act in the world, 1963, the second, 1965, for inland wetlands, and the codification, 1983. That would be contrary to announced decisions of this court.
Well, let me turn that around and ask whether you are comfortable with the extent of deference given by the commissioner to the hearing officer with regard to her findings.
Yes. She complied with vinyl, and furthermore, the case is distinguishable from vinyl, since this commissioner has rules about recommended decisions being just that, and receives the entirety of the record, including the briefs, and reviews and reads them, which is apparent from her 31-page decision addressing everything involving testimony, evidence, exhibits, arguments, and the like, and carefully articulates, as required by cases of this court, the reasons for disagreeing with subsidiary findings and any credibility judgments. And the Attorney General powerfully argues that even if we consider leaving subsidiary findings and credibility judgments in place, the commissioner decided that the errors of law by the hearing officer warranted the decision. The error of law being, hearing officer misunderstood what is a bank as a matter of law.
Mr. McGregor, let me ask you this. Are you telling me that when your client puts this load in, there are going to be no trees that are located in a bank, part of a bank? I mean, look at the photographs. They're right there. Half of the bank is in the water. your client is not going to cut down any trees?
What's before you is a decision of DEP upheld by the Superior Court, which found substantial evidence and correct interpretations of law consistent with the regulatory scheme as required by
No,
cases
just
of
what's
this
the answer
court.
to my question? You're not going to cut down any trees that are in the bank,
Well, the
part of the bank? What's the answer, yes or no?
Answer of the witnesses in the hearing was that nothing would be done altering the bank
No.
and
Are there any
violating the
trees?
standard of
Are there
impairing
any
its
trees
stability.
going to be cut down
There will be some trees and other vegetation cut down.
in
Remember-
the bank?
Well, remember, the bank is the vertical surface holding the water in.
Yeah, well, I've got
We
pictures.
mere mortals think the bank is where you stand and
No.
look at the stream.
No, but there's roots. You can see the photographs, roots coming down almost to the water.
Yes, in the
In
hearing.
on the vertical surface.
Yes, Your Honor, and the Commissioner addresses those in her articulated reasons for disagreeing as a matter of law about what that meant under the regulatory scheme that defines work in a
Yeah, as I
in the
read,
bank as
she may be
on.
right. She may be right, but the commissioner says you're going to cut down trees that are on part of the bank. You know, the tree is there, the bank is here, half the tree is, on the horizontal that we mortals think of as the bank, but we mortals also think there's a vertical part and it goes into the river. And she says you're going to cut those down. That is not work on the bank. A little hard to take.
The Attorney General is correct in saying those claims are speculative. They weren't proven. Half of our brief is addressed to what the plaintiffs rely on as
Well, if
this
the
of
answer-
necessity argument, this presumption, this of course it will happen. They ask you to draw a conclusion, apparently as a de novo tribunal, happy with looking at the mechanics of construction, that there'd be no way of avoiding it. Well, when someone says that somebody's
Well,
going to be...
look, you're putting a road through this, right? This is a heavily wooded area. What are you asking them to do? To say, stipulate right now where the road is, or just leave it to DEP sometime in the future to say, oops, this tree is not very valuable? I mean, there's a plot here, right? There's a plan that shows more or less where the road is going to go, and I think that's what they've done. They've gone and they've marked it out with the little blue flags. Your people marked it out with the little blue flags.
I'm glad you asked that. There is no resource area here called land underwater. This is not about a stream as a matter of law. This is one resource area, a bank.
Right. Yeah.
So while the plaintiffs want you to think that mountain streams are threatened, they're actually benefited by a voluntary, not required technology of bridging. It's as if you or I wanted to build a driveway across a ditch to our house or cottage or second home.
Mr.
That's the law that we're dealing with here today. That's why this case is important beyond just the administrative law points that the defendants have raised. It's arching it to avoid, not jurisdiction, but avoid the strict five-part performance standard for work destabilizing banks. One could argue, but if one has an adjudicatory hearing shouldering the burden of proof, they have to come up with evidence about where is the bank. It's not this part, it's this part holding water in. And what are those plants? What is the root structure? What rocks will be encountered? And it's not left to conjecture when the commissioner has to make a decision based on the entire record, as she does, when it all comes up to her to make what's called the final decision, which is under review here. Justice Spotsburg.
Mr. Pardee says if you are going to cut down a tree because of the road, then you need to notify DEP or the Conservation Commission, and there will be some discussion. Now, what do you say to that? When your engineers are out there and your people are out there planning this road and they see this tree that's got roots and actually part of the trunk along the vertical of the bank, are they going to call up what are they going to do?
I say one tree does not make a wetland. One tree does not
There's a
destabilize
question,
a
if you
bank. And of course DEP will enforce, and
No.
there's a monitor
Could
required
you
for
answer
this
Justice
work.
Bartlett's question? What are you going to do? Are you going to call up DEP or are you going to cut down the tree?
The project manager will ask DEP whether it needs a change in the plans, just like every other one of the 7,000 projects permitted each year under the Wetlands Protection Act. It doesn't end with a decision of the commissioner. after adjudicatory hearings, which are only like 0.5% of the cases in DEP.
Thank you, Mr. McCarty.
And good morning.